Well, hello and welcome to the September webinar of the Centre of Environmental Law and Nature Dialogues. I know we're really excited for today's webinar, and I'd like to start by acknowledging that I'm speaking to you from the unceded occupied lands of the Wadamadugal clan of the Darug Nation. I pay my respects to elders past and present for sustaining and continuing to sustain land, waters, country since the beginning of time, and extend that respect to Indigenous sovereign nations around the world where you might be listening from. Today, it gives us great pleasure to present a record-breaking Cell webinar. We have 371 people registered from all around the world, and it is my great pleasure to introduce Professor Liz Fisher, who is Professor of Environmental Law at the Corpus Christi College and Faculty of Law at Oxford University, Editor-in-Chief of the Journal of Environmental Law, and her topic today is what the history of nature conservation law tells us about ecological futures, a non-Euclidean vision of the Anthropocene. Welcome, Liz.
Thank you very much, and thank you very much for that warm welcome. It's a real honour to be here. As many of you probably know, I'm originally from Australia, and I, in a sense, owe so much of my kind of intellectual debt to being Australian, and in particular to my legal education in Australia. Now, I'm going to share my screen. I'm going to talk for about half an hour so that we have enough time for discussion. I thought I would start when Michelle reached out to me. I was really, really honoured to be asked, but I also jokingly said, well, actually, how can I resist when there's a picture of a kookaburra on the kind of advertising material. So I thought I would start with this picture of my son when he was a lot younger, who is very English, having his first experience with a kookaburra. And of course, this is a reminder that nature and society are entangled and have always been. But of course, in the Anthropocene, we are not just talking about entanglement anymore. What we are talking about is society as such a powerful and destructive force. What are we going to do about it? And that is, in a sense, what I'm thinking about today. And let me just, I can see, this is the bit where the technology doesn't work anymore. Why is my... Right, thank you very much, and sorry for the technical hitch. And as Donna Haraway says, we are living, and let me add, destructive and patchy, and I'll explain that in a moment, geo-stories. We must tell them well. How do we think about this? And how do we think about this as lawyers and in terms of governance? Now, destructive but also patchy. What do I mean by patchy? What I mean is that the impacts, the consequences, the causes of the Anthropocene are not uniform. And they are a reminder that as a global community, we are not one we. We are many we's, and we interact with each other, often with adverse consequences. So my theme today is, where did the cognitive resources for telling these geo-stories in law come from? Now, by resources, I do not mean tools, instruments, answers. Somewhere I have my magic wand, magic wands. I don't mean any of that. What I mean is a source of information, knowledge, thinking, ideas. And where do these ideas come from? That is the theme of today. And that brings me to, my rather ungainly and even pretentious title, What the History of Nature Conservation Law Tells Us About Ecological Futures, a Non-Euclidean Vision of the Anthropocene. And over the next half an hour, I will explain what this rather pretentious title means. And I will do that through 4 steps. First of all, I want to talk about what I see as some of the common assumptions about law in the Anthropocene. And I'm acutely aware this might have a straw man aspect to it, and it would be really good to talk about that. Secondly, I want to talk about what I see as the vitality of legal life. And I want to show that legal paths are a resource in thinking about legal futures. My third step is I want to give an example of this, which is nature conservation law. And I should say my use of the word history is I'm not going back. I'm not doing something like Tim Bonhatti's wonderful work, thinking about the history of nature in Australia. I'm really talking about recent history. But that history of nature conservation law and how that law has framed, worked, and imagined law and nature. And finally, I want to come to some conclusions. Now, first of all, an apology and 3 caveats. The apology is my office is right next door to Merton Chapel, and every 15 minutes we're going to get some bells. And I apologize on that. The 3 caveats. First of all, this is a work in progress. This is the beginning of the next big projects that I'm interested in. And for that reason, I really want to discuss some of these ideas. And this is, you know, I'm putting some ideas out there. Some of them are not as worked through as I normally would. Secondly, let me be very clear. In pointing to nature conservation law as a resource, I'm not saying it's perfect. Far from it. That is actually part of my point, is our experiences with the failures of this area of law can help us understand the future. And thirdly, as you can probably already tell, there's going to be some photos here. I'm drawing on anthropological literature. I'm drawing on fiction writers. You might think in doing that I'm being glib. I'm not being glib at all. We need to be serious about the Anthropocene, but part of that is opening our minds to other ways of thinking. Okay, so let me start. And law and the Anthropocene, some common assumptions. This photo, by the way, is of the flooding in Magdalen College grounds in January. And as you can see, a bridge doesn't normally be in the middle of the water, obviously. Right, so what are some common assumptions about law in the Anthropocene? Well, I think one of the most common is law is not fit for purpose. Here is Louis Coates, a South African writer, writing, law cannot continue to comfortably rest on foundations that evolved under the harmonious Holocene. That is probably a relatively moderate view. Many say, and I've heard people say, I don't believe in law as the answer to the Anthropocene. And what this has led to is an assumption that law needs to be going forward about radical acts, and they can be of many different sorts, that transcend our present imagined communities and their intertwined understandings of law and everyday life. Now that might take in very many dimensions. A lot of that is about saying, well, we need to get international. We need to get global. You know, we need to have a big treaty that recalibrates how we think about the world. It may be about talking in terms of a new kind of constitutionalism and talking about rights. But the key thing is that there is this disconnect with legal paths, an assumption that our legal paths got us into this mess in the first place. And so we want to, in a sense, disconnect from them. Now, to me, and just if you're interested, this is a picture of the Tay River Bridge up in Scotland, where, as you may know, there was a major disaster when the bridge collapsed in a storm and there was a railway on it. And of course, bridge engineering learnt a lot from that experience. What are the dangers of this approach? Well, to me, one of the most kind of problematic is this kind of utopia-dystopia binary. This danger that we long for a kind of different utopia, but we see dystopia. And as China Miéville, who is a speculative fiction writer, describes that bad hope and bad despair are mutually constitutive. And there's this kind of danger of a kind of vicious cycle that as people sort of think we need radical acts, they're not possible, well, all is lost. But secondly, and more importantly, not seeing both the value and possibilities of law and legal reasoning. What do I mean that? Well, the value of law is a body of thought, which is by no means perfect, but within it are embodied a set of well-worked commitments to ideas deeply committed to in society. Many of them are essentially contested. What is fair? What is rational? What is freedom? These are all issues that we debate, but we have developed a legal architecture and a group of institutions for doing that. And the interesting thing about environmental law is how much it is embedded in that architecture. We think about it as radical, but actually it uses all the resources of a constitutional state. But the second thing is about possibilities. So there is a temptation, a cliche, to have this fixed vision of law, rather than looking into our legal past and saying, actually, law has evolved and the sky didn't fall in. And what can we learn from that? So that brings me to thinking about the vitality of legal life. And this brings me to the second half of the title. The late and very great Ursula Le Guin, in one of her essays, which she explored the idea of utopia and what does it mean to be utopian, drawing on anthropological work with Indigenous communities in California. And this title, A Non-Euclidean View of California as a Cold Place to Be. And part of the essay is talking about the dangers of the kind of purity of thought that utopianism brings. And this line, which she draws from kind of Cree spoken word culture, to speculate safely on an inhabitable future, perhaps we would do well to find a rock crevice and go forward. In order to find our roots, perhaps we should find them where roots are usually found. And part of the problem is we need to learn from our experiences, and particularly our experiences where we commit to one single idea or one kind of pure thought about how the world should be. Now, to me, a lot of law is about that. We have commitments and we work them out in the law. So this brings it to this project. And as I said, this is really the start. To understand, and the project is really about to understand substantive legal paths. So not law, there goes the bells, not law as a tool, an instrument, outcome-based. We're thinking, I want to think about law as in terms of doctrine, which sounds very dry, to chart a course for legal futures. And that would serve as a basis to think about the type of legal expertise that needs to be developed for practicing lawyers, for scholars. And I call this legal imagination. And a lot of my work in the last year or so has been about this idea of legal imagination. And I'll talk a bit about it at the end. Now, I should say this is a hopeful project. It is time I'm drawing on the work of the anthropologist Anna Lau Pat Ting, it is time for scholars to look out beyond our models to the continuing vitality of life, both terrible and wonderful. So it's hopeful in the sense is it wants to reconnect with our legal realities and not engage in wishful thinking. And I'll explain that in a moment. Okay, just in passing, just one example of the possibilities of legal paths. Many of you will know this picture. This is John Snow's map of Soho, where he is recording deaths from cholera and showing that they were clustered around the water pump. as many of you probably know, in 1842 in Liverpool, the average life expectancy of a working class man was 17 and a half. Cities today, Liverpool today, is unimaginable to people back then. There was change. And in a sense, law was not the only part of the story, but law was an important part of the story. Now, admittedly, it took 40 years of legal reform to get there. And that raises issues about the Anthropocene. But the point is that there was a possibility of legal change. But I don't want to focus on that today. What I want to focus on is nature conservation law. Here is me looking very cheesy, literally, next to a sign for a national nature reserve just outside Oxford. This was taken on a very rainy New Year's Day several years ago. And I show you this picture because I was very keen, a little book I did a couple of years ago, I wanted a photo of one of these signs. And so I went out with my husband in the pouring rain to look for one. And we found lots of other signs for nature conservation sites, for sites of special scientific interests, for sites owned by nature trusts. And he kept with sort of delight saying, we found it. And I said, no, that's not the one I want. And that is just a very simple example of how the English countryside is scattered with these ideas of nature conservation law. And it's to that I want to now turn. Okay, so what lessons can we learn from nature conservation law? And this is going to be, I'm going to just draw on simple examples. I hope in drawing on them, you will be thinking of other examples. There is nothing exhaustive about this. The first thing to highlight about nature conservation law is its creative framing powers. So nature conservation law is primarily in terms of legislation, but legislation that does many, many different things for different reasons. So we have different reasons for protecting nature. If we think about the kind of preservation value of national parks in Australia, we don't see that in the legislation for national parks in the UK, where balancing tourism with kind of working life is kind of one of the aspects of it. We might value it because we want to value species, we might want to value beauty. And legislation has been created for all these different reasons. Legislation, and I'll show this in a moment, is also framing and valuing nature in different ways. And there are different legal logics to it. So what you find getting into nature conservation law is this kind of vast legal landscape of different things going on. Now, as some of you, if you teach this subject, students often find that very boring. But I find it really interesting. Okay, so just to give an example of different ways we might frame legislation. Recent work I've been doing with one of my American colleagues, this is, by the way, a tree in Magdalen College, is tree protection legislation. Very, very simple, protecting urban trees. And across the world, we see examples of legislation protecting trees for different reasons. I have the Australian Capital Territory, a section from them, to protect individual trees in the urban area that have exceptional qualities because of their natural and cultural heritage values or their contribution to the urban landscape. So we see three logics in there, three logics which are given legal meaning. But another way we might protect nature is through species protection. I draw here on a very early example from the US, the Endangered Species Act, which in thinking about protecting species in a sense and whether determining whether they're endangered or threatened, sets out a list of factors. Threatened destruction, modification, overutilization, disease or predation, the inadequacy of existing regulatory mechanisms or other natural or man-made factors. And of course, this has given rise to a rich body of case law, I'll come to that in a moment, about what do these mean? But the point is they are given legal meaning. And then the final example, and this brings me back to my sign, is enclave protection legislation. Now, in England, this is really the main means by which nature is protected. Now, by enclave, what I mean, if we go back to my little map, is that here is part of the map, and we say that part of nature, something different happens in that space. And this map I've taken from Natural England's. These are the different protected sites, not just of SSSIs, but other sites across England. Now, it looks a bit more impressive than it is because the dots are far bigger than the actual space. But it's interesting to look at it. One of the main ways in the UK that nature is protected is through what is known as a SSSI, a site of special scientific interest. And the criteria is laid down in the Wildlife and Countryside Act, where Natural England are of the opinion that any area of land is of special interest by reason of any of its flora, fauna, or geological or physiographical features. It is the duty of Natural England to notify. So this is this kind of special interest. It's a kind of scientific logic, which is different from many other forms of legislation. And finally, to give you a more recent example, but in a sense, a natural progression from those other examples, the Whanganui River Claims Settlement Act, recognizing the river as an indivisible and living whole, comprising the Whanganui River from the mountains to the sea, incorporating all its physical and metaphysical elements. And that has given legal personality. Now, my point is all these examples are all examples of giving nature legal definition and legal significance. And that leads to the next thing we see in nature conservation law, the need for active legal work. Now, active legal work, I do not mean activist. What I mean is this requires questions about what does this all legally mean? What are the legal consequences? How do we enforce? Particularly when what is going on with these different pieces of legislation, there aren't examples, there aren't precedents in that way that if you remember back to contract law, you have the deep grooves of legal reasoning where you kind of know, okay, I know how we legally go about this. So that active requires really actively thinking about what does this mean in terms of law. Now, part of that is administering nature. And I'll put this to one side, but I want to highlight it because it is important. The administrative and regulatory institutions are fundamental. So much of this legislation delegates to public administration, and there may be a role for private institutions. That's about information gathering, that's about enforcement, that's about regulating. And that raises really important issues about the capacity and expertise of the institutions we have. You may be wondering what this picture is. This is the biannual swan count that Oxford University runs down at Abbotsbury on the Dorset coast, where volunteers, and I and my children were volunteers, where you bring all the swans in together and you count them and you weigh them as a means of understanding what is going on with that population. But perhaps more importantly, it is also about adjudicating nature. It is inevitable, and coming back to my point, in the Anthropocene, we are not one big we. We are groups of different communities who have both positive and adverse effects on each other. And it is inevitable that there will be legal disputes, and there will be legal disputes that raise difficult questions. What is cultural value? What is scientific interest? These are all issues. And so in adjudicating, and I've just spelled interpreting wrong, but there we are. Interpreting legislation, enforcing that legislation, dispute resolution, and also accountability. So there is lots of legal work and adjudicative work that is going on in this space. Now, I just give, and this is not a particularly important case, but it's a really nice case of raising some of the issues. So this is a English case from about 12 years ago, the case of Boggis. This is the east coast of England, and the east coast of England is falling into the sea. And Mr. Boggess took matters into his own hands by getting out his tractor, ordering a whole lot of sort of dirt and sticking it in front of the cliff for it to be a sacrificial seawall. Now, he didn't have planning permission for that, so in actual fact, that was a serious issue. The dirt was also affecting a special protection area down the coast, but his argument was, well, the cliff is a site of special scientific interest because of its geological sort of aspects. And therefore, I am protecting the cliff. Now, the argument of the court was, no, well, the reason why it's of special scientific interest, that the court came to the conclusion, is because actually it's eroding. You know, the reason of its value is it's got these fossils in it, and as it erodes, we can see these fossils. That's what makes it valuable. Now, that is a kind of, and I can see people sitting there going, the reason I highlight this case is it's a reminder we are always working with these legal definitions. Okay, and that brings me to my third point and what we can see, the importance of legal imagination. And this is really where a lot of my recent work, I've been trying to get my head around this, which I suspect is kind of a pun, but I don't mean it as a pun. Law has, we tend to think of imagination as creative, as something, you know, imagination and law, aren't they contradictions in terms? But law is fundamentally a set of mental constructs. We teach those mental constructs in law school, we apply them in practice, we are constantly working with them. If I say contract, immediately a set of mental constructs come into your brain. And if you're like me, you're back in the class, because I don't teach contract, I'm back in the classroom again, thinking about those kind of core basics. What I'm interested in these fields is the way in which those legal mental constructs need to evolve in light of the ecological realities. Many of our legal constructs did not develop with ecological problems in mind. Now, that's not to say, people, when I say that, say, oh yes, but the Romans had sewers. Yes, they did. But in a sense, the core of our law, when we think about those flow diagrams, does not have ecology in the picture. And so the challenge in this active legal work is, how do we work with those established legal mental constructs in light of those ecological realities? And how do we do that well and robustly? And how do we do that well, coming back to my start, about working with those core legal ideas and recognizing, yes, there is a reason why we value fairness, rationality, etc., but recognizing we might need to rethink them. Again, apologies. Now, that is in all aspects of this. This is in legislation. And, you know, there are better examples and worse examples of nature conservation legislation. It's in administration. And perhaps most importantly, it's in adjudication. Now, and I know he's in the audience. Just to give you a very simple example of this, one of my favourite cases is Justice Preston's decision in Newcastle and Hunter Valley Speleological Society and the Upper Hunter Shire Council. I won't go into too much in the details, but what I would say, this case is a merits review in which the precautionary principle was applied. Now, what I find interesting about this case is, in many ways, it doesn't have the high profile of Telstra, but it builds on Telstra, and in many ways is a really interesting example of rigorous legal reasoning, albeit within a merits review context, of how do we think about the process of licensing activities in light of different types of uncertainties. So just a reminder of the case, it was a challenge by a third-party objector to a development consent for quarrying in limestone areas. Now, in the case, there were issues about surface impact, but there were also impacts about kind of within the cave system and within the karst system. And really, there was very little information about this. So it, you know, a very simple thing would be, well, it's probably not a problem. And the precautionary principle was argued in this case. Now, what we see, and I won't go, is how do we think about this? How do we resolve this dispute? What kind of active legal work goes into this? Well, you know, first, you know, in thinking about this limestone area, are there actually caves in there? There is one first kind of step. You know, is there water in there? Likely that you would have life in there. You know, is life likely to be present? And if it is, you know, is that, you know, is quarrying likely to threaten it? And therefore, what might happen kind of next? Now, I think what's really interesting here is here we have a series of steps. And again, you know, my experience with the precautionary principle is people tend to want to say, we get to the outcome. But here is a set of reasoning. And as many of you might know, in this case, moving forward, the approach was an adaptive management one. Okay, conclusions. Really what I've been talking about in thinking about resources and cognitive resources is really connecting our legal futures more robustly to our legal pasts. That's not to say our legal pasts should bind us, but to say we recognize the complexities, the pitfalls, the possibilities of our legal pasts so as to build legal expertise for ecological futures. So realizing where, in a sense, legislation looked promising, but never delivered, and why was that? To understand what kind of legal concepts people kind of found challenging, or in a sense needed far more work, active legal work. Now, a lot of that is also about rethinking legal stories. And I return to Donna Haraway, who building on the work of Ursula Le Guin, points out that stories as capacious bags for collecting, carrying, and telling the stuff of the living. And as Le Guin has pointed out, these are not single linear stories with dramatic arcs, with climactic moments where, you know, we're going to win or we're going to lose. They are far more assemblages about nature, about humans, about our weaknesses, and about our possibilities. And I think coming back to this non-Euclidean idea, it's recognizing that in thinking about our legal futures, these are complex legal futures. There is not a single act, there is not a single treaty, there is not a single institution that will answer the problems going forward. There are legal communities doing many different things. And that brings me to my final point, from legal wishful thinking to legal imagination. And this again, drawing on the work of Le Guin, in writing fiction, she talks about wishful thinking as thinking detached from reality. And she glibly, and you know, we can recognize problems with this. She says, you know, wishful thinking is the Third Reich. Legal imagination, which she says is connected to reality and comes back to inform it, is the American Constitution. And in thinking about our legal futures, it is that legal imagination that we need to both recognize the importance of and to foster. Thank you very much.
Thank you so much, Liz. And you can see people with their clapping emojis and clapping in person as well. That was fantastic. The way that we've linked past and possible future legal scholarship, but also potential ways of thinking about it, which go beyond the legal discipline, coming back to those speculative fiction writers through all of that as well. And I imagine there will be a lot of comments. Please use the raise hand function, or if you would like, put your question in the chat box and I will come to it. I will But I would draw your attention to one comment, which is, and the amazing Ursula Le Guin. While I'm waiting for comments to come through, oh, very nice. Caroline Foster, please go ahead and ask your question.
Oh, thank you, Michelle. Hello, Liz, and hello, everybody else. And thank you for such a thought-provoking presentation. It's going to be a really exciting project and it's really timely. My question is, I suppose, to articulate maybe a few further examples of what seem like either new concepts or concepts that are having fresh life breathed into them, and just ask how concepts like this might fit with the project. And of course, I'm thinking of some concepts that maybe transcend the national and the international. So the ones that came to mind for me were concepts of intergenerational equity and the well-being of future generations, the idea of the human right to a healthy environment, and what I think can also be considered an idea still at this point, is protection of biodiversity beyond national jurisdiction.
Great, thank you. And hi, Carolyn, it's lovely to see you. So in relation to all of this, so one thing to make very clear, I'm a comparative national environmental lawyer. I would never pretend to be a public international lawyer. And so my focus is very much on that. With that said, and you are not and actually most people, anyone who practices public international law is not in this category. There is a danger that I often find that people feel that the kind of answer to all our problems does lie in public international law without a kind of engagement with what is public international law, if that makes sense. And I guess what I would say is my argument, I think, also plays out in PIL, but in very different ways. In relation to these three concepts, these are things that I have been thinking about. So if we take intergenerational equity, I think one of, and New South Wales sort of very recent sort of desert protection and their protection of the Whanganui area on the basis of its intergenerational kind of value, I think is really interesting. So I think people often, when they think about the idea of intergenerational equity, they think about it as a discrete kind of legal idea that provides an answer, rather than a legal concept about equity that is then integrated into mainstream thinking, if that makes sense. Human rights, and clearly a huge and complex area, as my wonderful colleague Sanja Bogojevic, she's been doing a lot of work in this kind of space and thinking, you know, here we're thinking about rights for nature, we're thinking about rights to nature, and we're thinking about kind of procedural rights. And I can, on that last point, I can heartily recommend Emily Barrett's recent book on the foundations of the Artists Convention. And then this kind of beyond, again, I mean, I think that comes back to where I was starting, which was really this issue about recognizing that PIL is its own distinct legal culture. Carolyn, I don't know if that answered the question.
I suppose in some ways the emphasis was on the idea of new. So in the overall picture of the project and what it's seeking to do, looking back and looking forwards, looking for ways to develop perhaps our imagination, how do the relatively new ideas fit into that scheme?
So okay, and so I guess what I'd say is I think sometimes what we have to start with is the really boring stuff. So for example, statutory interpretation of nature conservation legislation. What kind of legal work needs to go into that? So the temptation to kind of say, okay, here we add in a new legal concept and that is the answer. Or what does it mean to think about Wednesbury unreasonableness in the context of judicial review of a planning application? So it's not saying that these new concepts are not irrelevant, but really saying in thinking about these new concepts, we need to tie it to that legal work. I can see people going, looking around the room thinking, my gosh, a course on statutory interpretation. But in a sense, that would be kind of where I would be going.
Thanks, Liz. And I've got, Tina, I can see you've got your hand up. I've got 2 questions in the chat box and I'll come back to you, but really good to see you. The next one links to the discussion we're already having from Roger Barrett. Roger, did you want to ask that question in person, or are you happy for me to read it out? I'll read it as I can't see you waving.
I can, do you want me to read it, Michelle?
Yeah, that's a good idea.
Okay, so I think Roger's question is a really good one, raising the issue about legal futures and how do we think about legal futures in light of other really important disciplines such as ecology. And thinking also about the institutional restraints on that. So first, and I've done a lot of interdisciplinary work in the past. I think the first thing I would say is we need to recognise that there is a distinct thing as legal expertise. And I think sometimes in interdisciplinary discussions, law slips back to the kind of answer. Years ago, I was on a project on the precautionary principle, and I was told that my task was to draft a legally unambiguous version of the precautionary principle. And when I kind of said that was probably not possible, the eyes started rolling. Law is interacting with other disciplines, but it is, sorry, I'll just, law is interacting with other disciplines, but in doing so, law is distinct, and it has this powerful framing role. Law tells us what in reality we should be looking for and what we shouldn't be looking for. So I tend to, in thinking about expertise, we need to recognise both our legal expertise, our contributory expertise as lawyers, but we also need to recognise that interdisciplinary expertise, that kind of interactional discipline expertise where we're interacting with other disciplines. Now, I agree that is institutionally challenging, partly because actually it's really challenging in teaching. And, you know, it is really challenging. How do we bring in another discipline without actually that discipline closing off the legal discussion? Now, with that said, I think what's really interesting is all lawyers are interactional experts. That law is always applying to problems out in the real world. We are always thinking about it. So although I think it's challenging, I think recognizing, yeah, we are always having to think about, if we're thinking about criminal law, you know, why does crime happen? If we're thinking about contract, what do we think the commercial world looks like? So that question, and then the other question, Michelle, and I don't know if Roger wanted to come back on any of that.
I think he's happy to type from what I can see. Roger, I think that's the case. But I will go to Kath and then to Tina. And Kath's question seems very much to go to your emphasis at the beginning on who is we, and this very increasingly rights-based approach to nature. But what about other ontologies where obligation is at the core?
Yeah, and I think this is, it's a great question, because I think one thing I would say is that if we look at all this legislation, actually there already exists a vast landscape of legal obligations to nature, of all different sorts. Some, and you know, most of them are incredibly anthropocentric. So people saying, oh, well, you know, what we need to solve it by having this legal right of nature. In actual fact, you could argue that has been existing for half a century or more. Because this legislation is giving legal rights in a kind of lowercase sense to nature. And it's thinking about how do we do that kind of well. And in a sense, and Kath's question, you know, how do we bring the ecological realities of that into the picture? How does law make sense of that when so much of what we do is, in a sense, coming back to the flow diagrams, party A, party B, the money went, the car went this way, and it ended up in this bank account.
Thank you. I can't see Kath looking to respond. So Tina, you've been waiting so patiently. Please go ahead.
Thank you, Michelle, and thank you, Liz, for the wonderful talk. I was dropped off from the connection for a short while, so my question is not covering the part A of your talk, but the rest of it I did hear. This is perhaps more a reflection than a question, but it's on a stem from the discussion on public international law or trans-jurisdictional aspects, and somehow I just feel a sense to strongly agree with the fact that there is a lot of work to do also within each jurisdiction to see how those dynamics between law and ecology, for example, interact in the daily activities of, for example, adjudicators. And it's been fascinating in our ongoing project on the role of use of habitats directive and scientific uncertainties and precautionary principle in individual courts to see how differently judges work with something like precautionary principle or then scientific uncertainty or ecology. And personally, I think that if willing to, and when willing to use that legal imagination and develop it, well, comparative work is of course sort of the first answer, because by that you learn of how others have done, but it also shows the great variety we are having and the solutions that are there already that for others to use. And in that sense, yes, I think the work it's sort of hard and even tedious to go through immense amounts of case law and trying to figure out how judges are actually figuring out the different dynamics between our principles we share with science and uncertainties and legal norms. But after that very, very hard work, I think the outcomes are quite fascinating. So thank you. Lots of what you said reflects so much on what's been going on now. So
thank you. And that the EU Habitats Directive provides a really interesting example because of ideas about kind of ecological integrity in it. I would also note it's not just judges, it's lawyers. So much, particularly in the common law system, depends on the arguments that lawyers put.
Yeah.
And if the argument is not put,
yeah.
it is and not explored, and that depends on an understanding of, and this comes back to my point of legal imagination, of what is it a lawyer thinks that they're doing and what is valid to kind of put forward.
Yes, absolutely.
Let's move now to the question in the chat box from Matthew. A mixture, it seems to me, of the question of time in all of this, time, urgency, but also one of compliance.
And I'm just, okay, so in terms of time, and as many of you probably know, that Ben Richardson has been doing fabulous work on time, and I'm not too sure I can, oh, sorry, I've got someone's screen. I'm not too sure I can add much to that. But what I would say is, of course, in thinking about what law does, law frames time. It gives us time, it is doing things with time. Now that may be in terms of simply saying, well, if you get this license or you get this planning application, you don't have to think about time anymore because you've got it. Or it may be about putting in an adaptive management regime and saying, no, actually, we're thinking of time going forward in different kind of increments. It may be quite dramatic, like the Victorian legislation and the UK climate change legislation creating a target in 2050. So there is so much, in a sense, legally we can do with time. But again, that's something we're not used to thinking about. In terms of the compliance issue, and this is something that I really did glibly go over in my thing, this is fundamental. This is, we can have the most beautifully crafted pieces of legislation, but unless it has sort of teeth, then in a sense, we come back to the problem of bad hope. China Miéville talks about the need for hope with teeth. So in thinking about compliance, it is about thinking about hope with teeth, although I think his teeth are probably sharper than the teeth I'm thinking of.
Thank you. I can see Irina Krasnova's on my screen. So Irina, would you like to ask your question directly?
Nature conservation was kind of inside the customs of many people back ago, many years ago. So what is the potential of their knowledge of kind of nature and man coexistence, so to say? What is the potential of their customs for the present ways for further legal imagination and legal development and like that? Thank you.
A really important question, and to me it has kind of it has three different dimensions. I mean, first of all, there is a danger of being legally centralist, if you like to use a term of Harry Arthur's, about thinking about our legal past. You know, what did the High Court of Australia decide? And recognise that given that nature and protection of nature is such a local kind of experience, and it is about culture. And if we think about Indigenous communities, you know, a culture about the entanglement of nature and society over thousands of years. And there is much to learn from that. So that's the first point. The second point is one about which, sort of moving on the legal centralism point, is legal pluralism, is recognizing in thinking about law, we need to recognize that actually in these spaces, there are legally pluralistic ways, by that other ways that we might recognize kind of forms of legitimate authority. Now that might be for good or for ill, but that is what is happening. A workshop I'm organizing in a couple of months, we have a fantastic paper from a young scholar who's just finished her doctorate on the caste system and forest protection legislation in India. So we need to also think, you know, our legal imagination is what we think, you know, is law. Now, you might think that sounds radical, but as I've shown before, you know, Australia on the one hand is very legally formalist, all that constitutional law reasoning of the High Court of Australia, but actually it has a commitment to tribunals, to far more legally pluralistic, which is embedded within its legal culture. And so thinking about legal pluralism is not necessarily kind of radical. And then there was a third point, which has completely slipped my brain, but if I remember it, but thank you. So I don't know if you had any thoughts on that.
Thank you, Liz. I mean, let it be Indigenous people. It's more appropriate for our time because customs in modern society are entirely lost, so to say. We just know something from literature, from some history. But Indigenous people have very valuable knowledge about which natural values to conserve, how to use them. Probably this knowledge may be very helpful in modeling the future law. I mean that. Thank you, Liz, anyway.
Thank you.
I am in this wonderful position of having a whole lot more questions in the chat box and 4 minutes to go. So I think I will err on the side of thanking Liz in particular. You've generated so much wonderful discussion, but thank you to all of you as well for your fascinating questions, and obviously just the start of a discussion, but also of engaging with our past so that we might imagine better, more hopeful futures. So thank you again, and this recording will be made available on our YouTube site. Thank you and good night, or good morning if you're in a different time zone.
Thank you very, very much for listening. I really appreciate it.
Thanks, everyone.